The tension in the congressional hearing room was so thick you could cut it with a knife. Justice Brett Kavanaugh sat behind the witness table, his dark suit pressed to perfection, fingers drumming against the polished wood as he prepared what he thought would be an easy defense of his judicial philosophy. Across from him, American actor Jonathan Roumie, he adjusted his microphone, his eyes deep and focused like a prophet's gaze. What happened next would leave everyone in that room completely speechless. Justice Kavanaugh had walked into this special oversight hearing, convened to discuss public trust in the judiciary, thinking he could easily navigate the questions from a public figure. After all, he was an associate justice of the Supreme Court with decades of experience, a legal mind that had shaped countless landmark decisions. Roumie was just an actor, albeit a well-known one, who dared to question the very foundation of his judicial approach. But Justice Kavanaugh had no idea what was coming. The moment Roumie opened his mouth, everything changed. What he pulled out next didn't just surprise Kavanaugh. It absolutely dismantled his entire premise and left him grappling for words he couldn't find. Before we dive into this incredible showdown, make sure to hit that like button and subscribe to stay updated on the latest discussions that are shaping America's understanding of justice. Trust me, you don't want to miss what happens next. This wasn't just another dry congressional hearing. This was about to become the most talked about moment, reflecting the soul of American justice in recent memory. Justice Brett Kavanaugh represented everything about the established legal system that many Americans both admired and felt disconnected from. At 59, he had built his career as a conservative jurist, culminating in his appointment to the nation's highest court. His supporters praised him as a constitutional textualist, meticulously applying the law as written. His critics saw him as someone whose interpretations, while legally sound, sometimes overlooked the profound human consequences they wrought. Kavanaugh's rise through the judicial ranks had been meteoric and carefully orchestrated. A product of elite education and a meticulous legal career, he often spoke about the importance of judicial restraint and adhering to the original meaning of the Constitution. His personal story resonated with many conservatives who saw him as living proof that intellectual rigor and an unwavering commitment to principle could guide the nation's most important legal decisions. But critics pointed out that Justice Kavanaugh's privileged position as a Supreme Court justice had at times insulated him from the harsh realities faced by ordinary Americans whose lives were shaped by his decisions. Unlike the struggling families whose fates hung on the nuances of legal interpretation, Kavanaugh lived in upscale neighborhoods, sent his children to elite private schools, and moved in circles where contact with the justice system was limited to theoretical debates in law review articles or friendly conversations at legal conferences. Justice Kavanaugh had a reputation for being sharp during oral argument, known for delivering incisive questions that often left attorneys struggling. His questioning style was direct and intellectually formidable, designed to expose weaknesses in legal arguments through rigorous inquiry. He carried himself with the confidence of someone who had never really been challenged on the moral or human impact of his carefully reasoned legal opinions. His strategy for this particular oversight hearing, which focused on public trust in the judiciary, had been developed by a team of legal experts who had guided dozens of high-profile figures through congressional testimony. They had prepared him for questions about his judicial philosophy, specific landmark cases, and the balance between precedent and social change. They had crafted careful answers that would satisfy conservative supporters while avoiding statements that might alarm moderate senators or the public. What they hadn't prepared him for was someone who would focus on the real-world suffering caused by the interpretive distance of legal theory rather than abstract constitutional debate. Today, he expected more of the same routine philosophical sparring. On the other side sat Jonathan Roumie, a 48-year-old American actor who had, in recent years, become a powerful voice for compassion and human dignity. Unlike many public figures who came to Washington with political agendas, Roumie arrived with a mission born of his deep personal convictions and his unique ability to connect with the human experience through his craft. He was not a lawyer or a politician, but he had been invited to testify as a prominent advocate for a more empathetic justice system, leveraging his platform to speak for those whose voices often went unheard. Roumie's background was starkly different from the typical congressional witness. While he had achieved international fame for his portrayal of a spiritual leader, he had always maintained a focus on stories that illuminated the struggles and triumphs of ordinary people. His work had immersed him in narratives of justice, suffering, and the profound impact of decisions made by those in power. He had witnessed firsthand through countless hours of research and portrayal how abstract concepts could translate into very real, often painful human experiences. His transition from actor to national advocate hadn't been easy. The political establishment initially dismissed him as too idealistic or too outside the system for the careful dance of legislative politics, but Roumie had proven them wrong by focusing on the stories of those most affected rather than partisan grandstanding. He had spent his time preparing for this hearing, building a reputation as someone who did his homework. While other advocates relied on sound bites, Roumie personally reviewed every testimony, every account, every piece of evidence related to the cases he intended to present. He approached this challenge the same way he approached a complex role, with meticulous preparation and an unwavering focus on truth and authentic emotion. Roumie wasn't just another public figure asking softball questions for the cameras. He was a storyteller and an advocate who had spent his life exploring the depths of the human condition. He knew the impact of indifference, the power of narrative, and the profound weight of moral responsibility better than anyone else in that room. The stakes couldn't have been higher. This wasn't just about whether Justice Kavanaugh's judicial philosophy would be affirmed. This hearing was about the future direction of American justice, about whether the courts would remain disconnected from the real struggles of ordinary people, or whether voices like Roumie could force a re-examination of conscience. Justice Kavanaugh had come prepared with talking points about textualism and constitutional interpretation. What he hadn't prepared for was someone who would present the lived consequences of those interpretations with such raw, undeniable humanity. As the hearing began, observers could sense the electric tension. Conservative legal groups had packed the gallery, confident their champion would easily handle whatever questions came his way. Progressive activists watched nervously, hoping Roumie could expose the problems they saw in the justice system's application. Neither side was prepared for what was about to unfold. The hearing started routinely enough. Committee members took turns asking predictable questions about judicial philosophy and legal precedent. Justice Kavanaugh handled these with practiced ease, giving smooth answers that revealed nothing controversial while reassuring his conservative supporters. Then came Roumie's turn. He didn't start with pleasantries or congratulations on his distinguished service. Instead, he opened with a simple question that made everyone in the room sit up straighter. Justice Kavanaugh, in your tenure on the federal bench, and especially on the Supreme Court, your opinions have consistently emphasized the importance of strict adherence to legal text and precedent. Can you explain how this approach, in your view, ensures that justice is equally accessible to all Americans, regardless of their background? Justice Kavanaugh's eyebrows furrowed slightly. This wasn't the typical question about constitutional interpretation he had expected. Mr. Roumie, I believe that applying the law as written, free from personal bias or policy preferences, is the purest form of justice. It ensures predictability and equality under the law for all. Predictability for whom, Justice? And equality for what kind of circumstances? Roumie repeated, his voice calm but resonant. I'm here today to advocate for the millions of Americans who feel that the law, as applied, creates two very different realities. Can you acknowledge that disparity in lived experience under the law? Justice Kavanaugh shifted in his seat, clearly uncomfortable with the direction this was heading. I acknowledge that our justice system is complex, and there are societal challenges. But as a judge, my role is to interpret the law, not to legislate from the bench or address social inequities through judicial fiat. It relates because your record and the philosophy you champion has shown a clear pattern, Roumie said, pulling out a thick binder filled not with legal precedents, but with personal testimonies and case summaries. In cases concerning access to basic legal protections, cases where the most vulnerable Americans sought remedies, your opinions and the principles you've upheld have often narrowed those pathways, making it harder for those without significant resources to find justice. How do you explain that disparity in outcomes and effective access? The room went completely silent. Conservative supporters looked confused. This wasn't in their briefing materials. Progressive activists leaned forward, sensing something big was coming. Justice Kavanaugh's face flushed slightly. Mr. Roumie, judicial decisions are based on numerous factors, including legal text, precedent, and constitutional principles. I don't make decisions based on a litigant's wealth or social standing. But the human impact doesn't lie, Justice Kavanaugh, Roumie continued, his voice growing stronger. And it gets worse. In cases where individuals without substantial resources sought to have their day in court, their access to appeal, or even basic legal standing, your court's interpretations have, in effect, often closed the door. While well-funded litigants with armies of lawyers seemed to find endless procedural avenues to advance their interests, Justice Kavanaugh was now visibly agitated, his hands gripping the table edge. I resent the implication that I show bias in my courtroom. These examples are taken out of context and don't reflect the complexity of individual legal issues. Are they taken out of context, Justice? Roumie asked, his tone sharpening. Because I have specific stories here. The story of Maria Sanchez, a domestic violence survivor seeking asylum, whose complex procedural delays eventually led to her deportation, despite clear evidence of threat. Her pro bono legal team worked tirelessly, but the interpretation of standing or jurisdiction in her case, principles you have often elucidated, meant her plea was effectively silenced. She was returned to a dangerous situation. The tension in the room was now electric. Republican committee members looked uncomfortable, realizing their distinguished witness was in trouble. Democratic members were taking furious notes. Sensing an opportunity, Justice Kavanaugh tried to regain control. Mr. Roumie, you're cherry-picking individual cases without understanding the full context of the legal arguments. I've built my career on fairness and equal justice under law, applied meticulously to the Constitution. Equal justice? Roumie's voice rose for the first time. Justice Kavanaugh, I have here dozens of accounts where the strict application of legal principles, however intellectually sound, has led to profoundly unequal human outcomes. Dozens of instances where justice wasn't equal at all. Stories of families torn apart, lives irrevocably altered, all in the name of procedural regularity or textual adherence. He held up the thick binder, letting it fall back onto the table with a loud thud that echoed through the silent chamber. And these are just a fraction of the cries for help I've encountered. Justice Kavanaugh was now sweating under the bright lights, his composed judicial demeanor cracking. These accusations are unfair and unfounded. I follow the law as written in every case. Do you, Roumie shot back. Because the law, as interpreted, seems to allow for a significant disparity in who can effectively access justice. That's not equal justice, Justice Kavanaugh. That's a system where legal sophistication and financial might often determine one's fate, while fundamental human pleas are often dismissed as mere policy preferences. The room buzzed with whispered conversations as reporters frantically typed notes. This was no longer a routine oversight hearing. It had become a moral reckoning, with Justice Kavanaugh as the central figure being asked to account for the human cost of his legal philosophy. Just when it seemed like Justice Kavanaugh might try to deflect with more legal jargon, Roumie delivered the knockout blow that no one saw coming. Justice Kavanaugh, let me ask you about the broad legal principles at play in the case of Laura Vance, or similar cases concerning fundamental due process? The question landed like a thunderbolt in the hearing room. Conservative legal scholars who had been taking notes suddenly stopped writing, sensing that something significant was about to happen. Republican committee members exchanged worried glances, realizing they had no idea where this was heading. Justice Kavanaugh's face went pale. For the first time since the hearing began, he hesitated before answering. His hands, which had been resting confidently on the table, now gripped the edge as if anchoring himself against an incoming storm. I handle many cases, Mr. Roumie. I don't recall every name or specific legal argument. His voice had lost the authoritative tone that had carried him through hours of earlier questioning. Legal observers who had watched hundreds of confirmation hearings recognized the signs of a distinguished nominee in serious trouble. Roumie smiled slightly, the smile not triumphant or cruel, but filled with the quiet confidence of an advocate who had prepared meticulously and was about to reveal the decisive human truth. Let me refresh your memory of the impact. Laura Vance, a young mother, unjustly incarcerated due to flawed forensic evidence that was later overturned. She spent years in prison, losing her children, her home, everything. Her initial appeals, handled by underfunded public defenders, were dismissed based on procedural grounds. Her pleas for a re-examination of the evidence were systematically denied, often by courts emphasizing strict adherence to appellate rules. Rules you, Justice Kavanaugh, have often championed as essential for judicial efficiency and finality. The details hit the room like physical blows. This wasn't abstract legal theory anymore. This was about a real person whose life had been shaped by the decisions of the system, decisions that the man sitting at the witness table had vigorously defended. Progressive activists in the gallery leaned forward, finally hearing the kind of concrete accountability they had hoped for. Conservative supporters sank back in their seats, realizing their esteemed justice was walking into a moral trap that had been carefully constructed over weeks of research and heartfelt connection. The room was now completely silent, every person hanging on Roumie's words. Even veteran reporters who had covered dozens of these hearings stopped typing, sensing they were witnessing something extraordinary. You spoke of judicial efficiency, of upholding precedent, but what of Alara Vance? What of the years she lost? The children who grew up without their mother, all while the wheels of justice, or rather the procedural barriers, turned slowly and remorselessly against her. Do you remember her now, Justice Kavanaugh? Not as a legal brief, but as a human being. Justice Kavanaugh's hands were visibly shaking now. The composed judicial demeanor he had maintained for hours was crumbling under the weight of being confronted with the real-world consequences of the legal principles he espoused. Every case is difficult, but I have to follow the law. His voice trailed off as he realized how inadequate his response sounded. The law, as he interpreted it, hadn't required Alara Vance's suffering. His unwavering application of certain legal tenets had made that outcome more likely. The law, Roumie interrupted, his voice now filled with a controlled fury that had been building throughout his testimony. Justice. Contrast that with the recent case of Sterling Holdings LLC, a complex commercial dispute involving millions of dollars, where a prominent law firm successfully argued for a complete rehearing of their case, citing novel interpretations of procedural equity, precisely because they could afford to pursue every possible legal avenue, every nuance, every expensive expert witness. Justice Kavanaugh, you often write about the importance of procedural regularity. How is it that the very rules designed for efficiency seem to empower the wealthy to endlessly litigate, while those like Alara Vance, with a clear claim of injustice, are left to languish behind procedural walls? The comparison was devastating in its simplicity. Two litigants, both seeking a second bite at the apple, vastly different outcomes. The only variables were their economic status and the quality of their legal representation, amplified by the judiciary's approach to procedural barriers. Justice Kavanaugh said nothing, staring down at the table as if the answers might be written there. His silence spoke louder than any defense he could have offered. You gave Sterling Holdings, with their team of lawyers, the benefit of every doubt, the maximum procedural opportunity. Alara Vance, unjustly incarcerated, received none of that. So please, Justice Kavanaugh, explain to this committee and to the American people how justice is equal when Alara Vance sits in a cell, her life shattered by a faulty system, while wealthy corporations can navigate every loophole. The explosion that followed was immediate and devastating. Progressive committee members erupted in outrage. Conservative members sat in stunned silence, realizing their esteemed justice had just been completely exposed not on legal grounds, but on moral ones. The gallery buzzed with shocked whispers as reporters rushed to fact-check the details of both scenarios. Justice Kavanaugh attempted one last desperate defense. Mr. Roumie, you're oversimplifying complex legal decisions. There were different circumstances. What circumstances? Roumie demanded, now standing at his desk. The circumstances that Alara Vance was poor and largely invisible to the system, while Sterling Holdings was rich and influential, because those seemed to be the only relevant differences between these cases in terms of effective access to justice. The committee chairman tried to call for order, but Roumie wasn't finished. Justice Kavanaugh, you want to talk about following the law? Let me read you something. He picked up a document from his desk. This is from your own confirmation hearing for the Supreme Court, when you said, and I quote, "The ultimate goal of our justice system is not just legal precision, but the pursuit of truth and fundamental fairness for all citizens." He looked up from the paper, his eye boring into Kavanaugh. Were you lying then, or are you living a different truth now? The room erupted in chaos. Republican members objected loudly while Democratic members demanded answers. Kavanaugh sat frozen, his mouth opening and closing like a fish out of water, unable to form any coherent response. I have always tried to be fair, he finally stammered. Tried? Roumie's voice cut through the noise like a blade. Justice Kavanaugh, Alara Vance spent years of her life in prison for a crime she didn't commit. Her children grew up without her. Her life, for all intents and purposes, was stolen by a system that prized procedure over truth and efficiency over humanity. Michael Brennan, whose father successfully litigated his son's way to probation for a more serious crime, referring to the original text, Michael Brennan, just started law school at his father's alma mater. How is that trying to be fair? How is that fundamental fairness for all citizens? He pulled out one final document, holding it up for everyone to see. This is a letter from Alara Vance, written after her eventual release. She asks if her children will ever truly forgive the system. She asks if she'll ever be able to rebuild her life. She asks why justice failed her while it protected those with resources. Justice Kavanaugh, can you look me in the eye and tell me that Alara Vance received equal justice under law? Kavanaugh couldn't meet his gaze. After 30 seconds of silence that felt like an eternity, he whispered, I followed the guidelines and legal principles available to me at the time. No, Justice, Roumie said quietly. You followed two different sets of principles. One that rigidly applied rules to people like Alara Vance, effectively shutting down her pleas, and another that allowed for nuanced, resource-intensive interpretations for the privileged. That's not justice. That's a system where wealth and power dictate whose humanity is acknowledged. The hearing room had never been quieter. Conservative legal observers sat in their seats realizing their champion had been completely dismantled on a moral, if not strictly legal, plane. Progressive activists wiped away tears, finally seeing someone fight for people like Alara Vance. Justice Kavanaugh had entered this hearing as a respected Supreme Court justice defending his judicial philosophy. He was leaving as a symbol of the profound disconnect between legal theory and human reality within the American justice system. The immediate aftermath of Roumie's devastating confrontation with Justice Kavanaugh was unlike anything Washington had seen in recent memory. Within minutes of the hearing ending, clips of his testimony were racing across social media platforms faster than wildfire. The highest human cost of justice began trending within the first hour, with thousands of Americans sharing their own stories of unequal treatment and the devastating impact of legal proceduralism on their lives. Legal experts from across the political spectrum were forced to acknowledge that Roumie had exposed a real and troubling disconnect between legal theory and human reality. Conservative legal organizations that had spent months preparing for the hearing found themselves scrambling to defend the indefensible. Their carefully crafted talking points about judicial philosophy and constitutional interpretation meant nothing when faced with the stark reality of Alara Vance's suffering compared to the procedural victories of well-funded corporations. The Heritage Foundation released a statement attempting to salvage Justice Kavanaugh's reputation. Justice Kavanaugh has served with distinction for decades. Individual cases or anecdotal stories taken out of context should not overshadow his overall record of meticulous judicial excellence and commitment to the rule of law. But their defense fell flat when commentators began examining Roumie's presentation more closely. What he had presented wasn't an isolated incident or a few cherry-picked cases. It was a documented pattern of the impact of a particular judicial philosophy on access to justice. Progressive organizations seized the moment. The ACLU released a comprehensive report they had been preparing for months, detailing systemic disparities in federal courts based on access to procedural avenues. Roumie's confrontation had given them the perfect platform to highlight issues they had been fighting for years. Jonathan Roumie didn't just challenge Justice Kavanaugh, said the director of a civil rights organization. He exposed the entire system that allows wealth and legal resources to determine justice outcomes in America. The political implications were immediate and far-reaching. While a Supreme Court justice cannot be defeated in a confirmation hearing, the public discussion surrounding Justice Kavanaugh's jurisprudence shifted dramatically. Republican senators, even those who steadfastly supported him, began issuing statements emphasizing the importance of judicial empathy and access to justice. Senator Patricia Williams from a purple state issued a statement saying she needed time to reflect on the serious concerns raised about the human impact of legal decisions. The defections sent shockwaves through conservative legal circles, who realized that Roumie's methodical presentation, rooted in human stories, had fundamentally changed the public calculus around judicial philosophy. Republican leadership found themselves in the impossible position of either defending what many now perceived as an unempathetic legal approach, or acknowledging the need for a deeper consideration of human consequences. Senate Majority Leader Johnson attempted damage control with a hastily arranged press conference, stating, Justice Kavanaugh has served admirably for decades. We will carefully review all the information presented during the hearing and continue to affirm our commitment to equal justice for all. But political observers noted the careful language that suggested a recognition of the significant damage to public perception. More importantly, for the long term, Roumie's performance elevated his status within the national discourse overnight. Progressive leaders who had sometimes viewed him as an inspiring but tangential figure suddenly recognized him as a powerful voice for ethical considerations in law and a champion for criminal justice reform who could deliver results on the national stage. Former President Obama's senior advisor tweeted, "What we witnessed today was more than just effective advocacy. Jonathan Roumie just showed the entire country what real moral accountability looks like. He's going to be a force for empathy in this country for decades." The praise came from unexpected quarters as well. Conservative commentator Michael Brooks, who rarely agreed with progressive positions, wrote in his column, "Regardless of your political views, what Jonathan Roumie accomplished yesterday should concern every American who believes in equal justice. He didn't engage in partisan grandstanding. He presented facts, human truths, and demanded accountability." Democratic leadership immediately began discussing expanded roles for Roumie in public advocacy campaigns. Within a week, he received invitations to join national commissions on judicial ethics and was asked to lead a new working group on humanizing the justice system. The media coverage was extensive and mostly favorable to Roumie, even from outlets that typically criticize progressive politicians. Legal commentators praised his preparation and his ability to present complex legal arguments in terms ordinary Americans could understand, emphasizing the human cost. His background as an actor gave him a unique credibility that typical politicians lacked when discussing the lived reality of justice issues. Even conservative outlets that typically defended Republican judicial nominees struggled to mount an effective defense of Justice Kavanaugh's record against the moral weight of Roumie's testimony. The Wall Street Journal's editorial board, while criticizing what they called emotional appeals, acknowledged that the disparities in effective access to justice revealed during the hearing raised legitimate questions about equal treatment under law. One prominent legal analyst wrote, "Regardless of your political affiliation, what Jonathan Roumie exposed today should concern every American who believes in equal justice. The disparity in outcomes based on legal resources and procedural interpretations is not a Republican or Democratic issue. It's a fundamental fairness issue that goes to the heart of our constitutional system." The impact extended beyond partisan politics into legal education and practice. Law professors across the country began incorporating clips of Roumie's questioning into their courses on advocacy and judicial ethics. His methodical approach to presenting human evidence and building a moral case became a model for how advocates should prepare for high-stakes confrontations. Professor Elena Rodriguez of Columbia Law School assigned the full transcript of Roumie's questioning to her trial advocacy students. "This is how you prepare for a critical examination." He didn't rely on gotcha moments or partisan attacks. He built an irrefutable case using documented human experiences and clear logical progression of impact. But the story didn't end with the hearing. Roumie's research had opened a door that couldn't be closed. Legal advocacy groups began requesting similar analyses of other federal judges' records, looking for patterns of bias in procedural access and the human cost of strict interpretations. Within a week, 3 more federal judges faced scrutiny for similar disparities in their courtrooms regarding how procedural rules impacted individuals versus powerful entities. The Department of Justice announced it would conduct a comprehensive review of procedural application patterns across all federal districts, looking specifically at the impact of legal representation quality and resource disparity on case outcomes. Laura Vance, the woman whose story had become the centerpiece of Roumie's powerful testimony, was granted an immediate review of her case. While legal experts cautioned that her ultimate vindication wasn't guaranteed, the massive public attention on her situation made it nearly impossible for the system to ignore her case any longer. The Vance case became a symbol of everything advocates argued was wrong with the current system. A crowdfunding campaign to support her children and her fight for justice raised over $500,000 in the first week after the hearing. Thousands of Americans who had never heard of Laura Vance before Roumie's testimony now knew her story and demanded justice for her situation. The Legal Aid Society of Texas announced they would represent Vance pro bono in her appeal, with their executive director stating, "Laura Vance's case represents thousands of similar cases across America where economic status and procedural barriers determine justice outcomes. We're going to fight not just for her, but for every defendant who has faced this kind of systemic bias. The case review revealed disturbing details about Vance's original representation and the procedural roadblocks she faced. Her public defender, overwhelmed with a caseload, had indeed been unable to adequately challenge the faulty forensic evidence or navigate the complex appellate procedures. In contrast, Michael Brennan III's private attorney, as referenced in the earlier context, had spent over 40 hours preparing for his case, hired private investigators, consulted with addiction specialists, and presented a comprehensive rehabilitation plan that convinced a judge to avoid prison time entirely. This isn't about the quality of individual attorneys, explained Vance's new legal team. This is about a system that provides vastly different levels of representation and procedural access based on a defendant's ability to pay and litigate. Lara Vance deserved the same quality of advocacy and opportunity that Michael Brennan received. The publicity surrounding Vance's case led to similar reviews in other districts. In Chicago, a federal judge granted a new hearing for Maria Rodriguez, whose case showed identical patterns to Vance's. In Atlanta, the case of Jerome Washington, sentenced to 3 years for drug possession, while a wealthy defendant received probation for a larger quantity of the same substance, became the subject of a federal investigation, now framed through the lens of procedural access and effective representation. Meanwhile, Michael Brennan III, whose case had been used to highlight disparities in the original text, found himself at the center of unwanted attention. The young man, now in his second year of law school, issued a statement through his attorney. "I am grateful for the legal representation I received, but I recognize that not everyone has access to the same quality of advocacy. I support efforts to ensure equal justice for all defendants." His father, the prominent attorney who had secured his son's favorable outcome, declined to comment publicly, but privately told colleagues he was reconsidering his approach to criminal defense work. Several attorneys in his firm reported that the publicity from the hearing had prompted them to take on more pro bono cases for defendants who couldn't afford private representation. The broader implications extended beyond individual cases or even individual judges. Roumie had succeeded in forcing a national conversation about the role of wealth and privilege in determining justice outcomes, bringing academic discussions about systemic bias into the mainstream political discourse. Bar associations across the country announced new initiatives to address representation disparities. The American Bar Association, which had previously focused primarily on professional development and ethics training, launched a major campaign to increase funding for public defender offices and expand pro bono requirements for private attorneys. Law enforcement organizations, initially skeptical of Roumie's criticism of the judicial system, began acknowledging the problem he had identified. The National Sheriff's Association released a statement supporting efforts to ensure that justice outcomes are based on evidence and law, not on defendants' economic circumstances or their ability to navigate complex procedures. Polling data showed that Roumie's confrontation with Justice Kavanaugh had resonated far beyond partisan political lines. 78% of Americans agreed that defendants should receive equal treatment, regardless of whether they have private attorneys or public defenders, or the ability to exhaust legal avenue. Even among conservative voters, 63% supported reforms to address procedural access disparities. The political impact on Roumie himself was transformative and far-reaching. He received speaking invitations from law schools, civil rights organizations, and political groups across the country. His public relations team reported receiving hundreds of calls from young lawyers asking how they could support his work on humanizing criminal justice reform. "I've been practicing law for 20 years, said one criminal defense attorney from Philadelphia, and I've never seen anyone articulate the problems with our system as clearly as Jonathan Roumie did in that hearing room. He gave voice to every public defender who has watched their clients receive harsher sentences or dismissals simply because they couldn't afford better representation or endless appeals." The response from young attorneys was particularly overwhelming. Recent law school graduates who had been considering corporate law careers began reaching out to public defender offices, inspired by Roumie's demonstration of how empathetic advocacy could create real change. The National Association of Criminal Defense Lawyers reported a 40% increase in applications to their public service fellowship programs in the month following the hearing. Legal recruitment firms noted an unusual trend of associates at major law firms requesting transfers to pro bono departments or seeking reduced-hour arrangements that would allow them to take on more public interest cases. The Roumie effect, as one recruiter termed it, was reshaping career priorities across the legal profession. Law schools reported an unprecedented interest in clinical programs that provided direct representation to indigent defendants. The University of Texas Law School saw applications to their criminal defense clinic increase by 300% for the following semester. What Jonathan Roumie demonstrated, explained Professor Lisa Chen, who directs the clinic, is that public defense work isn't just about helping individual clients. It's about challenging systemic injustices that affect millions of Americans. He's inspired a new generation of lawyers to see this work as both personally meaningful and professionally prestigious. The ripple effects continue to spread throughout the legal community. 3 states announced they would conduct reviews of their own state judicial systems, looking for similar patterns of bias in local courts' procedural applications. Colorado, Massachusetts, and Oregon each allocated significant funding for comprehensive studies of access to justice disparities in their state court systems. Legal aid organizations reported increased donations and volunteer applications from people inspired by Roumie's advocacy. The Texas Legal Aid Foundation saw contributions increase by 60% in the 2 months following the hearing, with many donors specifically citing Roumie's testimony as their motivation for giving. Corporate law firms, traditionally focused on high-paying commercial litigation, began announcing expanded pro bono commitments. 3 major international firms pledged to take on representation of indigent defendants in federal criminal cases, with partners acknowledging that Roumie's hearing had forced them to confront the reality of unequal representation and access in the justice system. The American College of Trial Lawyers, one of the most prestigious legal organizations in the country, invited Roumie to deliver their annual ethics lecture. The invitation was unprecedented for an actor and reflected the legal community's recognition of his impact on discussions about judicial fairness and advocacy excellence. For Justice Kavanaugh, the aftermath was swift and decisive in a different way. 2 days after the hearing, he issued a rare public statement acknowledging the importance of considering the human element in judicial decision-making and emphasizing the court's role in ensuring meaningful access to justice for all, not just access to the law itself. While legal observers understood this as a carefully worded response, it represented a significant shift in tone for a justice known for his strict textualist approach. The statement, released through the Supreme Court's Public Information Office, conspicuously avoided any direct acknowledgement of the specific cases Roumie had documented, but its very existence and its focus on empathy was a testament to the profound impact of the hearing. Behind the scenes, supporters were furious about what they viewed as an emotional ambush. Conservative legal organizations had invested significant political capital in defending Justice Kavanaugh's jurisprudence, and this public reevaluation left them scrambling to frame their arguments in more publicly palatable terms. The Federalist Society, which had championed Kavanaugh's judicial philosophy, found itself conducting urgent reviews of how to better articulate the humanistic justifications for their legal principles. For the first time in decades, conservative legal groups were forced to examine not just judicial philosophy, but also its perceived human cost when vetting candidates. More significantly, Justice Kavanaugh announced he would be implementing new protocols in his chambers to ensure that law clerks, during their research and brief drafting, were explicitly directed to consider the real-world implications and human impact of potential rulings. While critics argued this was too little too late, it represented an admission that Roumie's criticisms had merit. The new protocols sent ripples through the federal judiciary as other judges, fearing similar public scrutiny, began voluntarily reviewing their own decision-making processes, particularly regarding procedural dismissals and access to court. Court administrators reported unusual numbers of judges requesting data analysis of their past decisions, with an emphasis on litigant resources, a previously unheard-of practice in the typically insular federal court system. Justice Kavanaugh's colleagues on the appeals court, from his previous service, and even the Supreme Court, while publicly silent, were privately discussing the profound impact of Roumie's testimony. Legal ethics experts began using Kavanaugh's case as a teaching tool for continuing education programs required for all federal judges. The Federal Judicial Center announced they would incorporate analysis of human impact and access to justice into their annual training sessions, ensuring that all judges would be exposed to the issues Roumie had raised. The long-term implications for American politics were equally significant. Roumie had demonstrated that thorough preparation and fearless advocacy, delivered with profound empathy, could still triumph over political calculation and institutional power. His success inspired a new generation of progressive advocates to focus on substantive human stories rather than just partisan rhetoric. What Jonathan Roumie proved today, wrote one political commentator, is that Americans are hungry for leaders who will fight for real people facing real problems. He didn't just score political points, he potentially changed someone's life and exposed systemic problems that affect millions of Americans. The story of Justice Kavanaugh's challenged jurisprudence became a case study in law schools and political science programs across the country. Students analyzed Roumie's research methods, his questioning strategy, and his ability to frame complex legal issues in terms that resonated with ordinary Americans. But perhaps the most important outcome was the message Roumie had sent to future judicial nominees and to the judiciary itself. The days of sailing through hearings without being held accountable for the real-world impacts of judicial decisions were over. Future nominees would need to be prepared to answer tough questions about how their rulings affected actual people, not just abstract legal principles. As one legal ethics professor noted, Jonathan Roumie has fundamentally changed the confirmation process and the ongoing discourse around judicial accountability. No longer can judges hide behind legal jargon when their decisions show clear patterns of human cost. He's raised the bar for what empathy and accountability look like in our judicial system. The transformation was complete. A routine oversight hearing had become a watershed moment in American politics, all because one actor refused to accept that justice should be blind to the human suffering caused by its application. Thanks for watching this incredible political showdown where preparation met opportunity and justice found its voice. Jonathan Roumie didn't just challenge a justice, he exposed a system and changed the conversation about human justice in America. Make sure to like this video and subscribe for more stories about the political battles that are reshaping our democracy. The fight for equal justice is far from over, and leaders like Roumie are just getting started.